Morning, everyone. Thank you for joining us. My name is Rob Goodchip. I'm a partner here at Fenchurch Law. We're joined this morning by Chloe Franklin, one of our associates, and we are both in the construction and property team. We're going to be talking about the Defective Premises Act and the insurance issues that arise from strict liability question mark. Just some housekeeping to begin with. I think we're going to be aiming for around 35 to 40 minutes, but we should have some time for questions at the end. There should be a Q&A option at the top of your screen. So if you'd like to pop the questions in there as you go along, and we will take some easy questions at the end if we have time. The recording and the slides for today's webinar will be shared, I'm told by Michael, probably tomorrow, if not Thursday. So look out for that. And there will be questionnaire included. So please do give us your feedback, including any topics that you'd like to hear from us in the future. So today, here's what we're going to be running through. Here we go. So today we're going to start off with the landscape. Where are we? And to some extent, how did we get here? Chloe is then going to run us through some typical insuring clauses and talk a bit more about the DPA. I'm then going to tackle what's the duty that arises under the Act and essentially what is the problem, whether what we find ourselves was the intention of Parliament and the government, how the courts have tackled the issue to date, and hopefully leave you with some solutions and some tips as we close out. So, Building Safety Act. Many of you will be very familiar with the Building Safety Act. Why we're talking about it here? Well, the reason it's relevant is because it really does set the scene for where we find ourselves in terms of the Defective Premises Act. So the Defective Premises Act was introduced in 1972. It was essentially brought in to deal with what was thought to be a gap for purchasers of new build properties where they either didn't have a claim in contract or they would struggle to bring a claim in tort or negligence. The law, and I'll come on to it, but effectively the law in negligence has moved on slightly, but there is still this difficulty that those with an interest in properties find themselves, and this was exposed really by the Grenfell tragedy in 2017. So effectively, a lot of homeowners found that they either weren't the original contracting party, or they were subsequent purchasers, and or they didn't have claims in negligence. And one of the criticisms, and there are quite a few, but one of the main criticisms of the Defective Premises Act was that the limitation period was 6 years. So by the time a defect became known, very often this statutory remedy was no longer available because more than 6 years had passed. So what the Building Safety Act did, along with a number of other things, including BLOs and RCOs, was introduced this retrospective change to the limitation period for DPA claims. Initially, when the bill was first being discussed in Parliament, the suggestion was that the limitation period be extended to 15 years. Actually, the government had a change of heart in January 22 and extended it to 30 years. The reason being was that the research was suggesting that actually a lot of the developments and properties and dwellings that were affected by the Grenfell tragedy were constructed or achieved PC before 2007. So you really had this kind of sweet spot in the early 90s where a lot of those types of materials being used. And if the limitation period wasn't extended beyond 15 years, the issue that Parliament was seeking to address wouldn't be addressed and it would have limited effect. So we now have the Building Safety Act, which says that there is this retrospective change to the limitation period for DPA claims, meaning that any claim effectively back to the kind of mid-90s now can be brought if the requirements of the Act are met. There's arguably worse news, which came from the recent, fairly recent Supreme Court decision in BDW versus URS, and it's essentially that DPA claims can also be used in contribution proceedings. So it's possible that defendants won't just be facing claims from those with an interest in the dwelling or the properties, but also from from others and members of the project team. So I'm sure most people will be familiar with BDW, but essentially this claim concerned structural defects in some developments which were discovered at a point in time when the leaseholders and owners had no valid claims against BDW. BDW undertook to do the remedial works in any event. It then relied on this retrospective change to the law to bring a claim against URS, essentially saying that both it and URS owed the leaseholders a duty under the DPA, and that it was seeking a contribution from URS on that basis. And the Supreme Court, said it effectively had no choice but to apply the DPA retrospectively, as otherwise the kind of purpose of what the BSA was trying to achieve here would be undermined or defeated. So very clear that this retrospective effect will be endorsed and supported by the court. As we'll see here on the slide, the Supreme Court said that not applying the DPA retrospectively would defeat the purpose to ensure the cost of compensation was ultimately borne by those responsible for the damage. And just to set the scene, I think when we're dealing with the DPA, the Supreme Court made these comments about the DPA. They said it's been subject to trenchant criticism, and it referred to this commentary from 1974, which described the DPA as a measure which adopts excessively cumbrous means to achieve relatively modest ends. It's drafted in terms which are long-winded, ugly, and obscure, and which ultimately changes little, a poor show in view of the complications it creates in the process. Wow. All that in mind, we have a unprecedented change in the law, leading to a wave of claims against construction professionals, relying on an ugly and obscure piece of legislation, with, as we'll see, the relatively few authorities to assist us with its interpretation. So there's no surprise that this is an area which is also creating issues around insurance cover. I'm now going to hand over to Chloe, who's going to take us through the DPA in a bit more detail and touch on some common insuring clauses.
Thanks, Rob. So now Rob's taken us through the landscape, I'm going to provide a look at the Defective Premises Act, and more specifically the duties that are owed under the Act. Firstly, though, and referring back to the case of BDW, it's important to understand who the duties under the DPA apply to. In the BDW case, the court found that a developer can be owed duties under the DPA and can do so even if they themselves owe duties to others. This demonstrates just how expansive the duties under the DPA can be. I suppose the key takeaway from this is that main contractors would also be able to rely on the DPA as an avenue for claims rather than relying on contribution claims. And while this approach appears that the court's taken a broad view of the application of the DPA, the list of professions that owe duties under the Act does not extend to everybody, and specifically does not extend to the likes of approved inspectors. In the case of Herons Court and Heronsley Limited, the Court of Appeal noted that the duty holders are those that do work which positively contributes to the creation of the dwelling. Now, that may include architects and engineers who prescribe how the dwelling is to be created, and not just those who physically create it. Hence why inspectors were excluded on the basis that they weren't working towards the creation of the dwelling. They were simply working in a regulatory role. So now we've looked at that, we're going to look at the specific sections, and here we see section 1 of the DPA. This section outlines the duty for anyone involved in the construction of a dwelling. It imposes a duty on those involved with the construction or design of dwellings to work in a professional, workmanlike manner using proper materials. It also emphasises the need for the dwelling to be fit for habitation upon completion. So moving on from section 1, section 2A was a more recent introduction by the BSA. It set out duties for individuals or businesses working on existing dwellings, which is the differential between that and section 1. It mandates that such work be carried out professionally with appropriate materials and that the building is habitable upon completion. The provision aims to establish duties owed to those not covered by Section 1 of the DPA, with the purpose of this new addition to ensure that the duties owed under Section 1 of the DPA would be equally extend to those who are working on existing structures, such as renovations. And the final section I'm going to run you through of the Defective Premises Act is Section 6. This section is particularly important in that it prescribes that parties are unable to contract out of their liabilities under the DPA. It primarily states that any contract clause attempting to circumvent the Act's obligations would be void, thereby preventing developers and landlords from evading their responsibilities. Now we've had a bit of a whistle-stop tour through the Defective Premises Act, I'm going to have a chat through some typical clauses which we or policyholders may look to for cover for DPA claims. Firstly, we're going to take a look at the public liability cover insuring clauses. This would be a typical PL clause. It states, we will indemnify you in respect of all sums which you may become legally liable to pay as damages in respect of A, accidental injury to any person other than an employee, B, accidental damage to property, C, accidental obstruction, accidental trespass, accidental nuisance, accidental interference with any right of air, light, water or way, or D, unlawful detention, imprisonment or arrest. This clause could be considered restrictive in that it's only triggered by the policyholder's liability for accidental damages. Therefore, in situations where no sudden accident has occurred, it is unlikely to be triggered. For example, in claims where the property has simply been defective from the outset, the accidental element of the clause could be unhelpful. Also, there's a requirement here for damage to have occurred to the property, and this could be challenging to overcome for claims such as defective cladding, as there is no damage per se. It is just a defective element that makes the building unfit for habitation as it increases the fire safety risk. I'm going to take you to another example of a PL insuring clause. This one you could suggest is a little broader. It states, the insurers will indemnify the insured against all sums which the insured shall become legally liable to pay by reason of legal liability imposed upon the insured by law or assumed by the insured arising out of injury to any person, damage to property, interference to property or any easement or quasi-easement, denial of access, nuisance, stoppage of traffic, infringement of right of privacy or any like cause or consequential loss arising from the above. And as I said, the wording in this one is slightly broader in that it acknowledges liability imposed by law, which arguably would include statutory duties like those under the DPA. It also covers claims resulting from contractual liability in the as per the assumed by the insured wording. However, we still see that there's a requirement for damage here, which, as with the previous clause, brings up the issues of damage versus defect. Whilst the clause is broader in that it applies to a broader range of liabilities, it still requires damage to be triggered. Therefore, the likely interpretation by insurers is that it applies strictly to damage, and the presence of a defect, albeit with the increased risk of damage occurring, they would likely say would be insufficient to trigger the policy. We are moving over now to the professional indemnity insuring clauses. This is a typical clause that you'd see in a construction policy. It states the insurer shall indemnify the insured up to the limit of indemnity for the insured's liability for compensatory damages, claimant's legal costs and expenses, and defence costs and expenses in respect of any liability caused by negligence not more specifically referred to in this insuring clause, arising out of any negligent act, negligent error, or negligent omission committed by the insured. The key limitation here is that the policy only responds to damage as a result of negligence. Under a strict interpretation of the DPA, Section 1, negligence isn't required for a successful claim. Therefore, if liability under the DPA is strict, which Rob's going to explore a little bit later, i.e. without the need for negligence, this clause wouldn't respond to DPA claims where negligence isn't found. Here is a second example of a PI clause in a construction policy. It states, this one's a little bit broader again, in that it says the insurer agrees to indemnify the insured for legal liability to pay compensatory damages from any claim first made against the insured during the period of insurance and arising out of the insured's or subcontractor's performance of business services or multimedia activities, and where the claim arises out of any actual or alleged breach of professional duty, negligent act, negligent error, negligent omission, negligent misstatement, or negligent misrepresentation. As I said, slightly broader than the previous clause. It covers claims arising from any alleged breach of professional duty, including but not limited to negligent acts or omissions. On the face of it, this could encompass a DPA claim, even if liability is strict, as it is not restricted solely to negligent acts. A breach of the DPA duty to build a breach of the DPA duty to build in a workmanlike manner, so the dwelling is fit for purpose, could be seen as a breach of a professional duty, therefore triggering the clause. However, disputes over the interpretation of this may still occur. I've given you a bit of a whiz through those. I'm going to hand over to Rob to take you through the problem by reference to the authorities.
Thank you. Thank you, Chloe. So as Chloe said, effectively the problem that we're seeing because of the increase in use of the DPA is whether or not the duty under the Act is strict or not. And if it is strict, how we would trigger an insuring clause which requires there to have been negligent. So we're going to take a look back at the kind of genesis of the Act and how it's been interpreted by the court. We're going to start with the Law Commission report, which I mentioned earlier, from 1970. So it starts off fairly promising. When it's talking about the nature of the duty under the DPA, it says that professional men will be under an obligation to do the work which they take on in a professional manner, that is, with all due care and skill. Where they specify materials, their obligation will be to select them with due care and skill. So far, so good. However, the report goes on to say, and it's talking about the existing obligation at the time when the Act was introduced. It says the implied obligation is generally thought to have threefold application, covering good workmanship, proper materials, and fitness for habitation, all three of which must be met. So essentially here, and I'm going to come on to it in a bit more detail, but it's talking about whether the duty is a threefold duty or whether it is a composite duty. Less helpfully, the report then goes on to say, it may be that proper work with good materials will usually produce a house which is fit for habitation, but it is possible to imagine cases in which, however skillful the work and however good the materials, there is some defect of design or layout which makes the resulting dwelling unsuitable for its purpose. So essentially, the report is arguably unclear about whether the intention was for there to be a strict duty, i.e. what the mischief that we're trying to avoid is the dwelling being unfit for habitation, or whether in order to get there, you also need to show that the work was done or it wasn't done in a workmanlike or professional manner. Even less helpfully, when the Building Safety Act was about to be implemented, we had this guidance from The government, in a redress fact sheet, as you'll see, it's here on the slide, and it leaves us in no uncertain terms about what the government at the time thought about it. They said that liability under the Defective Premises Act is strict. This means that no fault or negligence has to be shown in the claim. If a building is not fit for habitation due to defective work, then a claim can be brought. There is no space within the Act to consider whether the defendant was at fault, and there is no burden on the claimant to prove that. I mean, that's fairly conclusive. However, this guidance was withdrawn in July 2022. There's very little on why it was withdrawn. The best I could find was essentially that it's been kind of supplemented by the Building Safety Act itself. So yeah, its weight and its legal standing is questionable, and in circumstances where we don't know why it was withdrawn, I'd say it holds limited weight generally, but it is unhelpful. It is unhelpful in this context because it's, as I say, it's fairly conclusive about certainly what the government thought about it. What do the commentators say? So there's an extract here on the slide from Keating on construction contracts, which is one of the leading secondary sources. When talking about the nature of the duty under the DPA, it says a person within the section doing professional work has to do it in a professional manner. Fine. It is thought that all persons coming within the section are under a strict duty to fulfill its requirements, and that it would not be a defence to show that the work was done with proper care. Again, unhelpful because it's essentially saying that it is a strict duty and it doesn't matter how good or otherwise the work was. If the dwelling is unfit for habitation, then that's enough. I've seen this relied on quite a few times. All I would say, I suppose, is that it's not been endorsed or referred to in any of the relevant authorities that I'm going to come on to now. So again, I would say it's got limited weight. But you know, we see it raised quite a lot, but I'm not aware that it's been relied on in any of the relevant authorities. So the court hasn't given its view on this particular extract. So the authorities. So dealing first with this, the nature of the duty, i.e., whether it's a threefold duty or a composite duty. The reason why this is relevant is because if it was a strict duty, arguably you wouldn't need to have points 1 and 2. So if the only relevant consideration was whether the dwelling was fit for habitation on completion, then it would be irrelevant whether the work was done in a workmanlike or professional manner and using proper materials. So how have the court grappled with this issue? First up, we have Harrison versus Shepherd Homes. This concerned cracking to some some piled foundations at a development in Hartlepool. Essentially, the claim was brought against Shepherd and against the NHBC on the basis that the dwellings were unfit for habitation as a result. Interestingly, Shepherd are actually arguing probably what you would feel be counterintuitive to say that there was a single duty. It's not clear from the judgment, but my expectation is that they were arguing that because it was probably a better argument for them about the fitness for habitation point as opposed to the nature of its work. But the High Court found that Section 1 gives rise to a single duty on builders, so that the obligation to do work in a workmanlike, or as the case may be, professional manner, is a duty which has to be read with the requirements as regards the work. The dwelling will be fit for habitation when completed. So quite clear, a single duty. However, the blue text was the preceding text. The court was reluctant to make this finding because it was taken to the relevant bits from the Law Commission report, which we've seen, and it was also taken to a Court of Appeal decision, which I'm going to come on to, and it effectively said it felt bound to follow that Court of Appeal authority, that there is a single duty. Again, slightly unhelpful, I would say, in the sense that it being a single duty, I think, leans into the argument that the duty is in fact a strict duty. This rationale has subsequently been followed in the more recent cases. So Southwark Park Road, better known, I suppose, as being the first case and only, as far as I'm aware, case where a building liability order has been made. Mrs. Justice Jefford said that it is well established that the duty under Section 1 is a single duty to see that the outcome is that the dwelling is fit for habitation. In Vanka, also Mrs. Justice Jefford, busy year for her in 24. She said the duty owed under Section 1 has been construed as a single duty to see that the outcome is a dwelling is fit for habitation when completed. So I think it's well established that there is this single duty, which could suggest that the duty itself is strict, as opposed to requiring consideration of negligence or the basis of the works. However, the courts have gone on to consider the standard of the workmanship itself. So first up, we have Alexander and Mercurius. This is the Court of Appeal decision I was referring to when we were talking about Harrison. Slightly unusual case because actually what it was concerned with was whether the DPA applied at all. In this case, the work was actually begun before the DPA was enacted, and then PC was achieved about 6 weeks after the DPA came into force. So actually the Court of Appeal was more concerned with what taking on of the works meant and when the duty arose. Interestingly, they found that the duty arose kind of immediately as soon as the work was taken on, not there being kind of a stopgap at PC, and that's when the duty arose. The reason why it's relevant here is because when they were talking about the duty, the judge said, the statutory duty must, in my judgment, be broken as soon as the bad workmanship or the use of faulty materials takes place. The relevant bit for our purposes is the reference to bad workmanship, because effectively, if the duty was strict, so what if the workmanship was bad? It would be irrelevant to the test whether the workmanship was good or bad if all we were really focusing on was the fitness for habitation. So that's the only Court of Appeal authority that we have in the area, and as we saw from Harrison, it's been followed, albeit reluctantly, by the lower courts. Moving on to Robinson and P.U. Jones contractors. This concerned a new build dwelling in Cheshire where defects were found in gas flues 12 years after practical completion. So the DPA claim at the time was time barred, and the court was grappling with whether the main contractor, in addition to its obligations under the building contract, also owed a concurrent duty of care in tort. For fans of pure economic loss and concurrent duties, this is very much your case. The court found that yes, D&B contractors can owe concurrent duties of care in tort, including for pure economic loss, where they have concurrent duties under the main contract. So one to be aware of, if only for that reason. This extract on the slide, when the court was grappling with whether or not that concurrent duty of care in tort arose, it was talking about the difference in a claim under the DPA. So even though the claim under the DPA was time barred, the court was dealing with it in order to assess kind of the benefit of there being a claim in tort. So as you'll see here, the court said, the only real benefit the claimant gets in such a case, over and above his rights under the contract, is the benefit of the extended limitation period under Section 14A of the Limitation Act. At best, therefore, it could be said that imposing a concurrent duty of care gives the claimant a potential limitation benefit, which he does not get under the 1972 Act. I think here what we're really looking at is what the court doesn't say, because what the court doesn't say is that, oh, and by the way, under a DPA, you would have, there would be a strict liability, which would be, to my mind, an equally, if not better benefit to a potential claimant than the extended limitation period that you get in your tortious claim. So I think the absence of the judge saying what the duty is under the DPA, and by the way, it is strict, suggests that the court didn't consider the duty was strict, that the duty is the same as you would get under your negligence or tortious claim. And the last of our authorities is the recent case of Vanker. I'm conscious that the barrister that was instructed by the Vankers had signed up for the webinar, so he might be listening. So I've got to be doubly sure to get this all right. But essentially, this concerned a new build home that was commissioned by the Vankers. They brought a claim against the main contractor, Marbank, and also the architect, SCD. The claims against SCD were time barred. So the claim in contract and negligence were both time barred. The only claim that the Vankers had against them was by virtue of the extended limitation period under the BSA in order to bring their DPA claim. So with that in mind, the judge's comments can only have been in relation to the architect, the claim against the architect under the DPA, and I'm going to take you through a few of those. The first one here on the slide concerned brickwork. So essentially there was water ingress, which was causing the external brickwork to fail. Ultimately, this wasn't found to be a breach of Section 1 of the DPA because it didn't render the dwelling unfit for habitation. But interestingly and importantly, for our purposes, the judge said it does not follow that because no such water ingress has occurred since remedial works were carried out, that the design was carried out with reasonable care and skill. If the design does not comply with any established practice and was not carried out with reasonable skill and care, it does not matter that the consequence is not the expected one. The next defect was a glass balustrade. Essentially, it didn't have the right kind of lamination, and effectively the court did find that this was a breach of Section 1 because if the glass was more likely to fail, and also there was a lack of a handrail, so it did render the dwelling unfit for habitation. But in terms of the architect's obligation, the court said the weight of the agreed expert evidence is firmly in favour of the conclusion that it was visually obvious that the glass was not laminated, and that this is something that SCD, exercising reasonable skill and care, ought to have observed at some point, either during the course of the construction or on practical completion. So very much pointing to the exercise of reasonable care and skill being a relevant part of the test. Otherwise, why say it at all, essentially? And to make matters even clearer, were it to be needed, the judge left us with these points in relation to the measure of damages and quantum. So essentially, Jeff had said there is a constituent element of the duty, which is to see that the work is undertaken in a professional manner. Where the defendant has failed to see that the work is done in a professional manner, and the result is that the dwelling is not fit for habitation, there is nothing in the statute to limit the damages recoverable. So I think the judgment actually draws it all together fairly nicely. Essentially, the judge was saying that this element to undertake the works in a certain way or professional way is effectively a necessary and constituent element of the duty. So yes, it is a single duty, but you have to look to how the workmanship is undertaken when you're considering whether or not the dwelling is fit for habitation or not. I mean, ideally, what we would really need and want to kind of take the argument off the table is a Court of Appeal authority to really just get home the point. But this is where we are at the moment. So I'm going to hand back to Chloe now and hopefully work through some solutions.
Yeah, now we have considered the court's position on the interpretation of the DPA and the importance of a carefully drafted insuring clause. It raises the question of how policyholders ensure that they do have cover for these DPA claims. We explored some of the typical clauses in both PL and PI policies earlier in the talk, but as we discussed, none of those options provided complete cover for claims under the DPA. Therefore, our suggested solution would be that where possible, policyholders push for broader wordings so that DPA claims are captured without any grey areas. The broader the clause, in our opinion, the better it is for the policyholder in this respect. We've provided a couple of examples here of clauses that are likely to respond to DPA claims And that would be the solution to the less favourable typical clauses that we saw earlier. I'll let you have a read of those. You'll note in each of these clauses, it doesn't include the requirement for negligence, nor does it require accidental damage to have occurred. Obviously, taking away the issues that we discussed earlier with the typical clauses. Obviously, it's not always going to be possible to agree a broader wording with an insurer. So the alternative to that would be to try and negotiate the inclusion of a DPA-specific extension, which would do the job without having to broaden the insuring clause. And finally, taking you on now to the takeaways from today's talk. The key takeaways, number one, the duty is seen as composite, although that is open to challenge. It's not enough to find that a dwelling is unfit for habitation or that the work was unworkmanlike. Both elements need to be present for a breach of the duty under the DPA. Number two, it's unclear if Parliament or government intended the duty to be strict. The wording of the Act certainly is capable of being read that way, and the government's own guidance around the time of the Building Safety Act initially stated that it was. But as that guidance has been subsequently withdrawn, no clarity has been given to the reason for that withdrawal. Number three, the courts have seemed to have a concluded view, but a recent Court of Appeal authority is needed to put this beyond doubt. The idea of a single composite duty was established early and seems to have been reaffirmed in the more recent cases of Vanker and Southwark Park Road. However, crucially, we still lack a definitive ruling on whether the duty is strict or not. Therefore, as Rob said earlier, a recent Court of Appeal authority is really needed in order to provide that confirmation. Finally, number four, wider insuring clauses or specific extensions are required to remove the argument around the application, the cover for DPA claims. From a risk management perspective, whether you call it strict liability or not, the DPA greatly expands potential liability for construction professionals and contractors. It's therefore essential for policyholders to consider wider insuring clauses or DPA-specific extensions to ensure their policy is responsive. And I hope that has helped some of you guys on understanding where the position lies with the DPA. We've got about 7 minutes left of the talk. If people would like to put their questions in the Q&A box, we'll try and work through some of them now.
Thank you, Chloe. I'm going to pick up on a few that were asked while we were going through the talk. So the first one was the scope extends to architects, planners, builders, suppliers, roofers, renovators, and even landscapers in the construction, building, improvement, extension, or renovation of premises? Question mark. I think the answer is yes. I think, as Chloe said, the only real kind of restriction that the court has placed so far is really on approved inspectors, which is the Heron Court decision from 2019. But yes, it's very wide. And as Chloe also said, the Act itself prevents people from trying to contract out of their duties under the DPA. So it's very wide and certainly an exposure that those in the construction sector need to be aware of. The next question was, under professional indemnity insurance, will a civil liability wording overcome the possible exclusion you highlighted? I mean, effectively, no. So you can't contract out of the DPA, so you would still have a liability that you'd hope would be insured under your professional indemnity policy. Whether or not that's triggered, again, might go to kind of whether the duty is strict or not. We think the court has a concluded view on that. I suppose the only other thing you would look out for, and to Chloe's point about getting a DPA extension, it's whether you would have a DPA exclusion in the PI policy, certainly one to avoid if you can. There's a question here about the language in the Act and whether referring to professional men aligns with diversity and inclusion. Yeah, I agree. I suppose the reason for that is it's just an old statute and it's a feature of the language. I suppose at the time. The next question is, surely PI notifications would or should have already been made under earlier policy years, hence subject to historic operative clauses. Yes, exactly. I agree. And it will all obviously depend on the fact, classic lawyer's answer. But what I think some did in practice was make kind of blanket or block notifications when there was the change in the law. Effectively, we've had, and I suppose how it would run would be, we've had these kind of claims suggested against us before, but they were defeated because of the 6-year limitation period. That's now been extended. The risk of a claim is now increased or heightened. But yes, as you say, you could certainly find a scenario where insurers will be relying on either known circumstances or exclusions and or existing notifications, which they would probably try and direct you to. Those are the questions in the box at the minute. We've got one more. Is fitness for purpose provision in a contracted PI policy an alternative way for cover to apply? Yeah, I suppose possibly. I can definitely see that. The typical, well, is there a typical one? They tend to vary quite a bit, but I can see a way in which you could secure cover via a fitness for purpose provision, because sometimes they will have a carve out to say, so long as it's liabilities which would otherwise have arisen, and certainly they could arise via statute. So yeah, I think that is another way that you could get cover. Give it another 10 seconds. Okay. If there are any other questions, feel free to either contact us directly. Our details are here on the slide, and we'd be more than happy to pick that up. Alternatively, you might even be able to drop it in the feedback questionnaire. So however you like. But thank you everyone for joining us today. The slides are going to be shared in the next couple of days. As I said, please do give us your feedback. It's always much appreciated. Thank you very much.
Thank you.